Well, as advertised, today we wanted to talk to you about managing some of the risks associated with losing staff and what they might take from your business when they leave your employment, including things like information that you say is confidential to your business, your customer and client connections, and other intangible bits and pieces that make up your business that define its place in your market. Now, we'll be looking at managing that risk from both what we lawyers call the front end and the back end. The front end is obviously the upfront management to avoid problems, and the back end being dealing with disputes or issues when they arise. Mainly we'll be talking about managing employment relationships through properly written employment contracts. I want to talk to you about a few practical strategies that can help deal with some of the risks as well. Some of those might look simple and obvious when we talk about them, but I can tell you that in practice the simple and obvious sometimes can be overlooked in the thick of day-to-day business. I'm going to talk to you first about some aspects of both upfront management of risks and dealing with problems after the event. But I mainly want to talk to you about what you can do at the front end to, I guess, minimise the prospect for problems when employment relationships end. I want to talk a little about the concept of confidential information, what it is, how it can be protected, how the law protects it independently of anything you do. And then Damon's going to come in and talk to you about using post-employment restraints in employment contracts to prevent unfair competition with your business after the employment relationship ends. Now, we are aiming to finish inside the hour. If you've got any questions as we go along, I mean, just please feel free to put your hand up and we'll deal with them as we go, but if you prefer, we can talk about them at the end as well. All right, in terms of problems, how do they look in practice? Well, I've got two examples for you. I'm not going to analyse them in detail, I just want to give you a feel of the types of things that happen. These are two real-life recent examples. I've just de-identified the participants. The first one concerned a fellow who was a salesperson for products to a very small segment of the retail industry. So he was selling consumables and supplies to a subset of retailers in Brisbane. And he was dismissed from his position because it had become redundant, according to the employer. He had a very simple two-page letter of employment that didn't say a great deal about confidential information or much at all, really, that was of help in this particular scenario. And the contract contained no post-employment restraints. So he was dismissed. The first thing he did, I mean, his employment had come to an end on an involuntary basis. He went off to another employer, and remember, we're dealing with a very small market, there aren't many players in it, to pick up where he left off. They took him on. He knew all of his old employer's clients. He knew what they bought. He knew how much they paid for it. He knew what credit arrangements they had and so on. So with the benefit of that knowledge and with the assistance of his new employer, he started to run around poaching all of his former employer's customers, and they started to hemorrhage business badly. Remember, this is a very small market, so there weren't a lot of players in it. There wasn't much business to go round, so it was a big problem. The second scenario concerned a real estate agent, very successful real estate agent in the housing market. She left her employer to join a rival agency. Bit different there. Her employment was regulated by a collective agreement, a properly done collective agreement. And that collective agreement contained provisions that were supposed to protect confidential information and also contained anti-competitive restraints. Now, she left her employer to go to a rival agency and did exactly that which the collective agreement said she couldn't do. She started to poach her former employer's listings, and of course she had all of the data of prospects, clients, listings and so forth on her iPhone because she'd been able to use her phone for her old employer, her own number, she took it with her, and for her it was just continuing business as usual. So again, the employer there started to hemorrhage business. There were some complex legal problems that arose out of that particular scenario. One is that a collective agreement, in my opinion, ceases to have any operation once the employment ends. It's a statutory instrument, not a contract. She did not have a contract that dealt with her post-employment competitive obligations. So that part of it was completely useless to the employer. The other thing, the same problem affected the confidential information provisions in the collective agreement, but with a further wrinkle, and that is the collective agreement, well, it waded on at length about confidential information. It didn't actually try to define it. It didn't say what information was supposed to be confidential. So both of those scenarios presented difficult problems for the employers affected by them to resolve. Now, there were some things we could do, and you'll see what they were as we go along. Rightio, so how do you deal with these problems or potential problems? Well, broadly, there's three things you can do or not do, I guess, to try to protect your interests. The first is you can do nothing and just take your chances. And by doing nothing, I'd include writing up an employment contract that doesn't deal with these things properly, a la the fellow in the retail sector that I just mentioned. The next thing you can do is you can negotiate an employment contract that does deal with confidential information or things you say are confidential to your business, that prevents use and disclosure of information you say is important to you after someone leaves your business, but without going to the next step of imposing post-employment restraints. And then the third strategy is to do both, that is proper contract, deal with confidential information, properly define it, etc., and also impose restraints against post-employment competitive activity. Now, people come to me not really knowing what they want when they're looking at an employment contract, and will say, well, what do I need? And we'll talk about these issues. And often I'll be met with the comment that, look, sure, you can do me a 20-page employment contract and it'll cost this much money, and yeah, you might say things about confidential information and you might say things about post-employment competitive activity. But my mate down at the pub, or my other lawyer, or my wife, or my friend tells me that these things aren't worth the paper they're written on. I hear that a lot. I hear it from my clients, I hear it from prospects, and I hear it even from other practitioners. And look, as a general statement of principle, it's just not right. And what I've done, just to illustrate that point, is on this slide and the next slide, and we'll talk about these cases in a sec, I've pulled out just from the last year. So the oldest case there is March last year, and the most recent is October last year. Between them, there's 6 or 7 decisions and cases where employers were able, using employment contracts that they'd done with their employees, they were able to do very forceful and effective things to prevent former employees from, effectively making away with parts of their business, parts of their goodwill. And that just demonstrates that, you can't enforce these things is just not right, because you can enforce these things if you've done them properly. So that first case up there, that Emeco Co International, that's a case out of Western Australia, and if you've kept an eye on our press, you'll know that we have an office in Western Australia now, so that's why a Western Australian case is a nice thing to talk about. In that case, a fellow who was a business development manager for a company in the mining industry, it supplied heavy earth moving and related equipment on a contract basis to miners. The case talked about a business development manager, this Brendan O'Shea. He left or resigned from his employment with Emeco to go to a competitor. He had in his contract a 6-month restraint against doing that, and Emeco took him to court to enforce it, and they were successful. So he had actually secured new employment, but was not able to actually do anything in that new job for 6 months. So that restraint only expired on the 3rd of February this year. For 6 months he was sitting on the sidelines. Damon will tell you a lot more about that case. The next one, that OAMPS Galt Armstrong, similar scenario, 2 senior insurance brokers. They left their employment because their positions were made redundant. They went to a competitor. The old employer took them to court on an urgent basis, raced off to a judge and said, give me an injunction. These guys agreed in their contracts not to compete with us for 3 years after they left. And the court, on an urgent basis, prevented them from taking up their new jobs, prevented them from, well, they were in their new jobs already, but prevented them from continuing in those new jobs. Now that case has yet to be determined wholly or finally, because as I said, it was urgent relief obtained within a matter of days, and that's the way these things normally unfold. What the final outcome is, well, who knows? It might go to a full trial, but more likely than not, having got that preliminary urgent relief, the issues between the parties will settle on some basis down the track. So we might never know what happens finally, but in the first instance, these fellows had agreed not to go to a competitive position for 3 years, and at first instance a judge said that's a good and enforceable obligation, so you can't start in your new jobs. The next one up there, that Wilson, HTM and Pagliaro case, that was in fact a series of cases heard in the New South Wales Supreme Court between June and September last year, and if you follow the financial press, you'd know a bit about it. It involved a fight mainly between Wilson HTM, which is a share broking house, and Ord Minnett, which is also a share broking house, a stockbroker. And what had happened, what that case was all about was that Ord Minnett poached 5 brokers from Wilson's to come across to them. And what happened was Wilson's, when they found out about it, alleged that Ord's had unlawfully persuaded these 5 fellows to breach their employment contracts with Wilson in negotiations that these brokers had with Ord's relating to how much they might be paid to come and work with Ord's, including sign-on bonuses. Now I forget the particular money that was involved, but I think the sign-on bonuses alone across these 5 fellows were in the multiple millions of dollars. So the allegation was that these fellows had breached their employment contracts, and that breach was ultimately proven by disclosing their revenue information out of their broking activities with Wilson to Ord's. Wilson said, look, that information's confidential to us, but more than that, these guys have all agreed in their employment contracts to keep it secret, and they've used it against us. And that argument was upheld. Ultimately, what happened in the case is that on an urgent basis, all 5 brokers were restrained from going to going to Ord Minnett for 2 months. Now that mightn't sound a long time, but 2 months is a pretty substantial window of opportunity to try and salvage the client relationships that these brokers would have had with their clients. The other interesting thing is that there were no post-employment restraints in the contracts. The whole case revolved around breach of duties in an employment relationship and breach of the employment contract. So the first thing that happened is these fellows were restrained on an urgent basis. The second thing is that ultimately Wilson was successful in getting a damages judgment against Ord's for the unlawful activity that Ord's was found to have engaged in, and that is was inducing these guys to breach their employment contracts by disclosing their revenue information. Now the cost of the litigation would have been hideous. I can't even hazard a guess at what they were. But the background picture was these 5 fellows kept out of the market for 2 months, and in addition to that, the judge ordered that Ord's pay Wilson damages, and it was something just under $200,000. So it wasn't a lot of money in the scheme of things. But he did that on the basis that had things unravelled according to what everyone should have done, these fellows would have been with Wilson's for another month, and during that month they would have generated 175 grand in net revenue for their employer, and so that was the damage that they'd suffered. And then of course I think there would have been a cost order on top of that, but you don't generally hear, those things aren't generally published, so we don't know. But I think that was a very significant outcome for Wilson's, who were able to do things based on the employment contracts they had with their brokers to protect their patch. But the next case, AGA Assistance, Damon's going to tell you a bit more about that. That's a case out of Brisbane. That involved a salesperson working for a travel insurance company. She'd agreed that if she left them, she wouldn't compete against them for a year. The Supreme Court held her to that obligation. Again, another example of rights that were taken and were enforced. The next case, a bit of a different scenario. That Burdanko nominees, Burdanko is one of the corporate entities associated with the accountancy firm of RSM Bird Cameron. They're a big firm out of Western Australia, but they have offices in, among other places, Melbourne, and this case was out of Melbourne. Mr Money was a junior accountant there, and he'd agreed in his employment contract that he wouldn't pinch clients that he'd worked with or poach them for 3 years after he left the firm. He also agreed that if he did, then he'd pay damages according to a formula in his employment contract. Well, as things unfolded, he did leave. He did poach or take a particular client with him. RSM Bird Cameron took him to court to enforce the restraint obligation, and they were successful. The end result was he was allowed to keep the client, but he had to pay for the privilege. So he had to pay $200,000 nearly for the privilege of servicing this particular client on the basis that his 3-year restraint was good and he should be held to it. So he had to pay the money but could keep the client. And then the last case I had up there for you, the oldest case, that was a 2-year restraint against, 2-year restraint enforced against the founder of a HR outsourcing company. The slightly different wrinkle there was in the deal that the HRX Holdings had with Mr Pearson, they had agreed to keep paying him for the 2-year restraint period. So that was one of the factors that, in that case, the court said justified enforcement of the restraint. But in all of the others, people weren't paid to sit on the sidelines. They didn't have to be. It's not a requirement. So those case examples really put paid to that suggestion that these things don't work. There are going to be examples of situations where doing nothing or very little in the employment contract side of things is going to be justified. So with junior level employees, you're not going to do 7-page restraint documents or detailed contracts relating to the protection of confidential information, because if people in those situations leave, they're unlikely to have information that they could use against you, and even if they wanted to, they're unlikely to be able to set up in competition against you. So putting those situations to one side, if you do have a sensitive relationship with a senior employee, even if you haven't done things properly, there are remedies available to you under the general law, and we'll talk about those in a second. I mean, the law does provide some remedies for the protection of certain types of information in some situations. Before I come back to the detail of what that looks like, I just wanted to cover one other thing. Confidential information is one group of rights that we talk about as part of your intellectual property, but there are, of course, others. Sorry, I think I'm a slide behind. So if you've got some of these other types of confidential information, then there are other things you can do and should be doing outside of the employment contract to protect them. So copyright is one example. In the business world, we're generally looking at literary works which are protected by copyright. Generally speaking, those protections are automatic. Not all of them, but most of them are automatic. Trademark law, which protects things like distinguishing marks or business names or devices like the Coca-Cola ribbon device, sounds, smells and things like that. Those protections aren't generally automatically available. If you think you've got something that can be protected by registration of a trademark, then you need actively to go out and claim your trademark and get it registered. And same with unique inventions protected by patent and design law. If you've got inventions that or unique business methods even that you think should be protected, then you need to actively do something to claim those protections. So putting those things to one side, if you've got rights of that kind, or if you think you've got rights of that kind, you should go and get advice about what you should be doing to properly protect them. And by and large, what's in the employment contract won't have much to do with those things. Having said that, and again, I'm not going to talk about it in detail, there are things that should be in the employment contract to maximise your ability to exploit these other types of IP as it's developed in your business. Now, back to confidential information. In the employment context, there are different default rules that apply during the employment relationship on the one hand and after the employment relationship is ended on the other. While the employment contract is continuing, the law will imply, or the employment relationship, let's assume there is no employment contract, there is a duty of good faith or fidelity that the law implies into the relationship. It's the duty of good faith owed by the employee to their employer. You can describe that duty in many different ways. It can be adapted to deal with all sorts of circumstances, but at its most basic level, it includes, for example, a duty to act honestly, a duty not to divert business opportunities, to pinch business opportunities, a duty to obey your employer's lawful and reasonable directions or instructions, all part of this duty of good faith or fidelity. Now, that duty extends to include a duty not to use or disclose information you've acquired during the course of your employment, except in a way that's for the benefit of your employer or as per your employer's instructions. And that duty is pretty much absolute during the course of the employment, so while it's continuing. So again, another example, it would prevent an employed solicitor of this firm, for example, running their own legal practice on the side. I mean, they know about our clients, they know about the client's problems, they know about the opportunities to perform legal work. All of those things they know, and that's information, whether it's secret or not, that we say is ours and is to be used for our benefit. And we can insist upon that amongst our employees as part of their duty of good faith and fidelity to us. And if they were to act contrary to that, that would be a very big deal. We could do something about it. In that Wilson and Ord Minnett case that I spoke to you about earlier, one of the bases for the claims by Wilson against Ord Minnett is that the brokers had breached this duty of good faith when they disclosed their revenue information to Ords. They were still employed when they did that, trying to get a new job with Ords. And the court found that disclosure of the revenue information, regardless of whether it was a secret or not, was a breach of the duty of good faith. And that was part of the basis for the findings that I described earlier. Now this default rule, or default rules that come out of this duty of good faith and fidelity, they change when the employment relationship ends. Now, while the law can extend to prevent the use or misuse of confidential information after an employment relationship has ended, the rights that you have are much more vague and uncertain, particularly where you don't have an employment contract that seeks to describe the rights. And that, of course, is the critical point. That's the point at which it becomes obvious that if you had a contract dealing with the information that you wanted to protect, and explaining or obligating your former employee not to use it against you or to your detriment after they leave, that's when the value in that arrangement becomes very significant or obvious, because otherwise we're trying to deal with quite difficult concepts relating to the protection of confidential information. We're trying to pluck from the general law those concepts and apply them to your situation. There's a bit of an academic debate about whether this duty of good faith or fidelity that I spoke of, that exists during the employment relationship, actually has any ongoing effect after the employment relationship ends. Most of the cases, and I can't think of one that goes against this, most of the cases assume that once the employment ends, the duty of good faith and fidelity is out the door. So what then are the rules that apply? Well, the rules that apply are you will be able to take some steps to prevent information that you say is confidential, provided you can establish a number of things that give rise to what the cases call a duty of confidence. This duty of confidence can survive the end of the employment relationship, and you can use it to assert rights. So what do you need to establish this duty of confidence? Well, the first thing you need, if you're going to run off to court and say my employee has got information that they are using to my detriment or disadvantage, you need to be able to identify. It has to be specific. It can't be the vibe. They know enough about my business to cause me harm. That's not going to get you there. The second thing you need to establish is that the information has what the cases call a necessary quality of confidence. So it doesn't need to be complicated or a unique or novel invention, but it does need to be something that's unique to you and something which you fairly and properly regard as of value to your business. So really what we're talking about are true trade secrets. The last thing you need is you need to be able to establish that the information was acquired by your former employee in circumstances that gave rise to this duty of confidence. And you can do that in one of two ways. Firstly, if you can show that you instructed the employee that they were to keep particular things a secret, and you did that clearly and unambiguously, well, that will give rise generally to the duty of confidence, provided the other elements can be satisfied. Or if any person of reasonable and ordinary intelligence would have realised that the information that they were acquiring or had access to was to be treated as confidential. If it was obvious, despite the absence of specific instructions, then that might be enough to establish the duty of confidence. So if you think you can meet each of those tests, well then you've got a case to run off to court to prevent an employee using that information against you, but you're not quite there yet. The court will have a look at the information you say is important and is at risk, and it will try to categorise it in accordance with three broad categories. The first is if the information is publicly available, then you're not going to get there. If it's publicly available, it can't be secret, so that's the end of it. The second is, well, if you think it's secret and important, but the court regards it as trivial and valueless, well, that's not going to get you there either. So that's the first category of information that the courts have pigeonholed information into, and if you fall within that group, you won't get anywhere. At the other end of the scale are the genuine trade secrets. So things like the 11 secret herbs and spices at KFC, or Coca-Cola. I think if you research those, you'll find that the only way those things are protected is because they're secrets. There's no patent running around protecting them. They're not protected in any other way other than the fact that those corporations keep that information inside and they keep it secret. But less glamorously, other things have been held to be trade secrets capable of protection. So a detailed written business plan, for example, will be something usually that can be protected as confidential information. Specific compilations of data that relate to clients and prospects and your ability to maximise opportunities from them, that can be protected as confidential information. And that Emeco Co decision out of Perth that I mentioned was, to some extent, a bit of an illustration of that. Revenue information not publicly available, like in the Wilson and Ord Minnett case, that type of material will usually be protected as confidential. Now, when you're in this situation, so you've got no contract or no effective contract, and you've run off to court to try to protect information that you say is important to you, the outcome is going to vary from case to case and according to the circumstances. You're going to have to establish that what you're trying to protect amounts in effect to a true trade secret. And if you can do that, then you've got a good argument to say it should be protected by this ongoing duty of confidence after the employment ends. I've mentioned up there on the slide Section 183 of the Corporations Act. It imposes a similar statutory protection against improper use of information by former employees and others of corporate employers, and most of us work for companies, so Section 183 might be engaged in many of these cases. You'll generally find that if an employer runs off to court trying to get orders protecting information of the kind we're talking about, they will plead or use Section 183. But you're not going to get Section 183 to apply to you unless you can establish that the information in question is of that secret nature that we're talking about. Then there's this third category of information, which is, I guess, the difficult area. And it's information which an employee is obliged by that duty of fidelity I spoke about earlier to keep secret and not to misuse during the course of their employment. For example, because they were told to do that or because it was obvious that they should do that during the course of their employment. But if it falls short of being a true trade secret, then assuming there's no employment contract that regulates the subject, then information that falls into this grey area isn't going to be protected from use against you after the employment's ended. So the duty of faith goes away after the employment contract ends. So too does any obligation to preserve and protect confidential information that falls into this third category of grey area, I guess. So things like knowledge of your former employers, clients and customers, that's not something you can protect generally. General knowledge of what the employer's business is all about, what it's doing, what its plans are, what project it's involved in, who its prospective clients are, that's not going to be protected. Sales or pricing information by itself is not usually going to be protected. So the upshot of all of this is if you haven't tried to manage these issues in the employment contract in some way, then you're going to have a very difficult time trying to prevent use or misuse of the information in a way you don't like after the employment's ended. But the good news is that that exposure can be successfully managed or very significantly reduced through a properly written employment contract that's done at the beginning of the employment relationship. The other thing you can do, of course, is impose post-employment restraints, which Damon will talk about in a moment. Before he does that, there was a third scenario I mentioned at the outset, and that is, well, what if I've got a situation where I'm employing an employee who will have access to information that will be sensitive and might be used against me after they leave, but they won't agree to a restraint, or for whatever other reasons a restraint's inappropriate. What can I do then? Well, what you can do then is you can negotiate an employment contract that just deals with the confidential information. There are situations in our labour market at the moment where high flyers will say, I won't agree to a restraint. They might agree to keep information of particular kinds a secret, and that can be used to protect your business after the employment relationship ends, and I'll illustrate that in a moment. The other scenario where you might want to, or where it'll be appropriate just to avoid any discussion about restraints is, as I said earlier, some types of employees aren't going to represent a competitive risk. But nevertheless, they will have information about your clients or about your business or about your clients' businesses that you will want them to keep secret after you leave. So in those cases, it'll be appropriate, I would say, to include obligations in the employment contract that prevent disclosures of that information other than in circumstances that you've allowed or controlled. As for the senior person, there's a case I've put up there called Great Southern Events and Pescops, and that illustrates the point. Great Southern Events was an event management company, and Mrs. Pescops worked in it as an event manager, and she, when she joined the company, refused to sign up to post-employment restraints. But she did agree to keep information which was specifically defined in the contract confidential, information relating to clients and financial information of a particularly detailed kind. Now, as things came to pass, she left, and she then started to work for 5 key customers of that Great Events business. Great Southern Events raced off to court for an injunction to prevent her from doing that, based on the argument that under her contract she could not possibly do anything for these clients except through use of information that she had expressly agreed in her contract not to use. And the court upheld that argument. They restrained her. They ordered that she stay away from 4 out of those 5 customers. One was a charity and she worked for them for free, so the court didn't care about that. But the other 4, she had to stay away from them for more than 8 months, based simply on the fact that she'd agreed to keep certain information confidential, and a finding by the court that she couldn't work for these customers except by breaching that obligation. And where the 8 months came from, well, the court just made an assessment of how long the information would remain a secret and valuable. Because it was financial information by and large, it was going to lose its value over time. And the court said, well, after 8 months, all bets are off. But that's a very good example. I haven't seen it repeated, I don't think, in any other cases, but nevertheless, the legal principles upon which it's based, I think, are sound, and we use them all the time in difficult scenarios to enforce rights that our clients want to enforce. So that then leaves us with this whole hog approach where, in addition to in the employment contract properly defining and restricting uses of confidential information, you would impose post-employment restraints, and Damon will talk about that. I just wanted to leave you with a couple of practical thoughts. And that is, if you're going to do employment contracts and put provisions in them dealing with confidential information, we'll actually have a think about what it is you're trying to protect. As you've heard me say, the cases are keen to know with specificity what it is you say is confidential and why it's confidential. So have a think about that and describe it in the employment contract. It might be just one thing. It might be a particular computer program that you've written yourself. And we do that all the time. We describe particular important things for our clients in their employment contracts that they say are critical to their business and that they don't want used in any way, shape or form by former employees after they leave. Have a look at the practical rules in your organisation about how confidential information, which you've defined, can be used or disclosed. Publicise the rules, make them clear, whether in the employment contract or in policies around them. The other thing to do is to take some care to prevent or at least control the circumstances in which information that's important to your business is allowed by employees to be migrated to other platforms. I've put up there a case that's a 2001 case, and it concerned the old fight we used to have. I mean, it's only 12 years ago, but the old fight we used to have was about diaries and address books. And that case highlights the difficulties of protecting this stuff where there is no employment contract, but you want to claim the information is confidential. In that case, a real estate agent or a property manager had kept property listing information in an address book and similar information in a diary, both of which belonged to her, and she left and she started to use it in the context of a new employment relationship. So the employer, LJ Hooker at Blackwood in South Australia, took it to court to recover those things, saying it contained information relating to them. We haven't got time to talk about it in detail, but the outcome, which was reasonably perverse, was that she couldn't keep the address book because that contained information that was confidential to the real estate agency, but she could keep the diary, which was her record of day-to-day activities, but by and large which had a lot of this information in it. And again, it all revolved around these principles I've just spoken to you about. Today we have the fight around electronic devices, and data migrated to those. Can it be kept? How did it get there? Did it get there legitimately? Did it get there illegitimately? And so on. A classic area of argument is around mobile phones. If you employ someone in a sales position with a mobile phone that they provide themselves and which is their number, well then you're asking for trouble, because mobile phones are one of the best methods for walking your clients, your prospects and a lot of your business right out your door. And that harks back to that real estate example I gave you at the beginning. The other thing you can think to do is impose what I've called gags upon how information can be disclosed to the public. I mean, if you've got specific sensitive projects or tenders and things like that going on in your organisation, you don't want that out in the public domain, whether it be in a press release or someone speaking to the media casually or putting something on their LinkedIn page or their Facebook page or whatever. Because then it's public, then it's gone. So if you want to protect that information, you need to impose some rules around it, whether in the employment contract or just around instructions through policies that you give your employees along the way. The other thing that I think can be useful in some situations is when someone resigns from your employment, don't let them tell anybody. They've told you, but they don't need to tell their clients. The only reason they'd tell their clients, who are your clients, is to set themselves up in their new lives down the track. I had an employment contract at a firm I worked for years ago that said just that. When I resigned, I wasn't allowed to disclose it, except in circumstances that the employer controlled. And I think it's wholly appropriate. You don't need it in the employment contract, but you do need to jump on it, obviously, as soon as someone resigns. Now, look, that's all I had for you, so I'll hand you over to Damon. Sorry, Damon, I've pinched 10 of your minutes, mate. But
there are a lot of myths about using restraint of trade clauses in an employment context. As Andrew's already alluded to, employers often tell us that they think restraints are not worth the paper they're written on because they believe they won't be enforced by a court. Another quite common misconception is that some employers think restraint clauses can be used to prevent any type of competitive activity by a former employee once the employment relationship ends. After today, hopefully you'll have a better understanding as to why neither of these disparate views are correct, and also how to appropriately use restraint of trade clauses in an employment context. First of all, why use restraints? Andrew's already alluded to the fact that the common law doesn't provide a lot of protection in respect to activity which might be detrimental to an employer after the employment relationship ends. But one of the reasons why, but there are many reasons why you should consider using restraints, not the least of which is the ongoing war for talent. Restraint can prove a pretty effective deterrent for employees jumping ship, provided they're properly incentivised. But aside from that, a good restraint of trade clause will effectively prevent a former employee from a number of damaging types of activity, such as soliciting your clients and customers, poaching your staff, misusing or exploiting confidential information or intellectual property, and also setting up a business in competition with your business or joining a business competitor. Employment restraints can provide your business with certainty and help you to manage the commercial risks which are often associated with the departure of a key employee. In respect to the latter point on the slide, we're often instructed to issue letters of demand on behalf of our employer clients to former employees who they believe are in breach of their restraint obligations. And as part of that letter of demand, we'll ask for written undertakings. And they're a very effective tool because they often obviate the need to actually institute court proceedings. Written undertaking can form a written or contain a written acknowledgement in respect to the specific types of breaches which have occurred. Also containing promises as to how those breaches might be remedied, and also providing promises in respect to future behaviour that the former employee will be a good boy or girl. And that can form very useful evidence if down the track the employee does breach those undertakings. The other thing to bear in mind is when you run off to get one of these interim injunctions from the court, you can be looking at spending anything from $50,000 potentially up to $100,000 in legal costs in a staunchly disputed matter. So undertakings and letters of demand from your solicitors can provide a very effective deterrent to these type of behaviour, and it's a lot more cost effective than going to court. I just wanted to move on to the general principles behind what we call the common law restraint of trade doctrine. Perhaps fittingly, the doctrine of restraint of trade was laid down by the High Court at the turn of the century in a case involving one of the companies which went on to pioneer the maximum machine gun, which revolutionised warfare in World War I. And you'll see running through my presentation today, I've decided to adopt a bit of a warfare theme, which is probably consistent with this type of litigation. The general rule is that restraints are void and unenforceable on public policy grounds, and that's because they are seen to unduly fetter or restrict an employee or a person's ability to trade their labour in a modern capitalist economy. The exception is, of course, or as with any good legal rule, there are exceptions, and the House of Lords said that's where there's special circumstances which warrant reasonable protection. The rider being that the onus of establishing that those circumstances exist is on the employer, that is the person seeking to enforce the restraint. So in terms of the basics, the restraint of trade doctrine says that you can only use restraints to prevent unfair business competition. A mere or bare restraint which prohibits any type of competition by a valuable employee who departs your business will be unenforceable because it prevents fair business competition as well as unfair business competition. So you need to ask yourself three key questions when considering using a restraint of trade clause. And the first that is whether or not there are any legitimate interests which exist which are capable of protection. The second is whether the restraint is reasonable in respect to the protection it affords. And thirdly, you need to consider what type of restraints can be used and drafting methods to ensure that the restraint goes no further than is reasonably necessary to protect those legitimate interests. Now, the courts have developed over a period of time a number of special interests that are capable of protection, and they're outlined on the slide. But it's worth bearing in mind that the common law is continuing to develop in this area. But to date, in broad terms, the legitimate interests you can protect are trade secrets, confidential information and intellectual property, which Andrew's discussed. You can also protect the personal customer connection which is developed by the former employee during the course of their employment relationship with your customers and clients. And you can also protect the personal connection which they might develop with work colleagues and, in some circumstances, important business suppliers. So presuming you have these legitimate interests, the common law doctrine of restraint of trade says that you then need to consider whether or not the restraint goes no further than is reasonably necessary to protect those interests. And when you undertake this evaluative exercise, and indeed when the court ultimately might rule on one of these restraints, it considers what we call three dimensions, and those are the type of restrained activity to which the restraint relates to, the duration of the restraint period, and also, in some cases, the geographic area of operation of the restraint. In terms of types of activity, this is probably the hardest part of framing an enforceable restraint. The restraint must be tailored to the individual circumstances relating to the particular employment relationship. The reason why is if the nature and extent of the restrained activities is unreasonably wide, it may render the restraint entirely unenforceable. Or alternatively, if the restrained activities are not carefully drafted, then gaps or loopholes may be left enabling the former employee to engage in activities which are detrimental to the employer's business interests. Commonly restrained activities include approach, canvass or solicit any clients or customers, In respect to that particular type of prohibition, there's a couple of things you need to bear in mind. There must be a reasonably strong personal connection between the employer, the employee and those customers or clients, or there would likely to be so. Now that connection can have been made some time before the termination of employment, but if it's starting to get beyond 12 months before that particular client has had any dealings with the employee, then arguably the connection will wane over time and it won't be sufficient to support a restraint of that nature. Another common misconception is the meaning of the term solicit. A lot of people think that means that provided the client or customer doesn't come, that I don't make the first approach and the client or customer comes to me first, that's not solicitation. And the New South Wales Court of Appeal says, look, that's wrong. It's an overly mechanistic interpretation of the phrase or the term. And indeed, if you respond favourably to an initial approach from a client or customer and you're subject to one of these restraints, that will constitute solicitation. Another commonly type of restraint activity is use or disclosure of confidential information, and Andrew's already discussed the need to broadly define that and why in the employment agreements that you have in place. Another common type of activity, well, not so common, but it's not unusual, is that a restraint will say that you cannot work for a business competitor or set up a competitive business for a period of time. There are a number of different formulations used to try and capture all of the type of surreptitious activities which can occur when setting up a competitor business. The first up there is carry on or be engaged in terms of the drafting methodology. The courts have held that that won't pick up steps taken to prepare to compete, whereas the latter phrase or formulation, be concerned or interested in, will. So it's obviously the preferred approach. In terms of the next dimension, sounds very Doctor Who-ish, of scope is the restraint period. And this can also be quite problematic for drafting a restraint because there's no hard and fast rules around determining a reasonable restraint period. The court will determine this by undertaking an evaluative exercise, weighing up all the evidence in respect to the particular case and in particular the nature and strength of any connection with the employer's legitimate interests. This will normally involve considering a number of factors, including the status and role of the employee and not surprisingly, their key duties and responsibilities, and also level of remuneration, any specific industry factors peculiar to the business or the industry in which the business operates, the length of time it will take for a new employee to get up to speed and effectively replace the former employee and rebuild that customer connection, and also all that personal customer connection. And also often overlooked is the last factor, is the financial burden on the former employee of enforcing the restraint and for how long. Enforceable restraints for longer than 6 to 12 months are not common, but as Andrew's alluded to, there have been some cases where longer periods will be enforced by the court, although they often turn on their particular circumstances. And the example of the junior accountant in Burdanko is a useful illustrative example of that. In that particular case, the junior accountant had actually been seconded to the client that he eventually pinched from the accountancy practice. So he'd been embedded with that organisation for quite a long period of time during his tenure with the accountancy firm. So he developed quite a strong personal connection with that particular client. So in that case, the court thought, or the Victorian Court of Appeal, no doubt, no less, thought that was a reasonable period of time. Not every junior accountant is going to be held to a 3-year restraint. These matters often turn on their individual circumstances. And the final dimension in respect to scope is the geographic area of operation. Where you have a restraint which is general in nature, such as prohibiting an employee from accepting employment with a competitor in the same industry, it should be restricted to operating in a defined geographic area. Now, the factors taken into account when considering the restraint area include the extent of the relevant business activities of the employer, the extent of any access by the employee to valuable information of the employer and any business development activities it's undertaking, and the level of threat to the sometimes differing locations in which the business is operating or intends to operate. However, not all restraint clauses need to be limited to a geographic area of restraint, geographic area of operation. For example, a restraint which prohibits the soliciting of former clients may still be inherently reasonable in nature, where, say, because of the respective location of the individual clients and the confined geographic area in which they conduct their business or trading activities, for all intents and purposes, the restraint will go no further than is reasonably necessary to afford protection to the employer's legitimate interests. So that's all the principles that apply to the restraint of trade doctrine. When drafting restraints, you need to take into account that there are two types of restraints. Non-compete obligations, which prohibit competing with your former employer or working for a business competitor, and non-solicitation obligations, prohibiting an employee from poaching his staff, clients and customers, and sometimes your suppliers. Non-compete obligations are much more difficult to enforce because, of course, they effectively prohibit a former employee from exercising their living or right to earn a living for a period of time. So to deal with these issues in terms of particularly where you have a legitimate interest which is capable of protection, but you've got to determine what is the appropriate scope of the restraint, there are often two methods commonly used to tailor the restraint to address those issues. And the first is to draft a singular restraint, a definitive application. And in Queensland in particular, and common law states, and I'll come to this, the use of a step clause or cascading restraint. Now, when I mentioned that there are some states where there are differences, for example, in New South Wales they have legislation which deals with or modifies the common law restraint of trade doctrine and allows courts to judicially read down restraints which are singular in nature. But in Queensland, in Western Australia, where the common law applies without statutory modification, the common law restraint of doctrine says that if in respect to any particular aspect of the scope it is too broad in nature, then the clause will entirely fail and it'll be void and unenforceable. So what us lawyers commonly do is to draft step clauses and cascading restraints to try and overcome this problem. And it involves including a number of different options in relation to both the duration and geographic area of operation of the restraint, which becomes progressively less restrictive in scope. Effectively, an employer hedges their bets on what the court might decide will ultimately be a reasonable restraint in terms of its scope. Now, I just wanted to run you through a couple of case examples to demonstrate these principles in action. I've called them war stories. And in terms of the Western Front, the WA case of Emeco and AGA, which Andrew earlier alluded to, this particular clause is an example of a combined singular and cascading restraint of trade clause considered by the WA Supreme Court. And it's a singular, well, first of all, it includes two types of restraints. It's got the non-competition restraint, which prevents you working for a business competitor. And then it's got two non-solicitation clauses dealing with pinching business from the former employer. But in terms of it being a singular restraint, it's a singular restraint in respect to the area of operation. It's confined to operating in Western Australia, but it's a cascading restraint in respect to the duration. It applies for a period of 6 months, but if the court finds that that's unenforceable, it'll apply for 3 months. To give you some background facts as to why the court found that particular parts of this restraint were unenforceable and other parts were enforceable, O'Shea was employed as a business development manager by Emeco, a company carrying on the business of dry hire of mobile mining equipment. And that means that the equipment's hired without any actual plant operators. He was principally based in WA, but also worked in South Australia from time to time. And Emeco also had business units throughout Australia and overseas. O'Shea was one of a small number of BDMs in the company who were described as the face of the company. He reported to the state manager and was well remunerated with a salary package in excess of $100,000 per annum, and also was eligible for incentives including performance shares in the company. After working for nearly 2 years with Emeco, he decided to jump ship and join a business competitor called National Plant and Equipment, or NPE, and he signed an employment contract with them and resigned with the intention of immediately starting work once the notice period ended. Emeco got wind of this and successfully applied for an interim injunction. And then after a number of months, at the final hearing, the court determined that parts of the restraint were enforceable and other parts weren't. The judge made a number of factual findings which were critical to its decision, or his decision. The dry hire industry and market was narrow and highly competitive. There were a relatively large number of competitors supplying equipment to a relatively small number of clients. Emeco had around 20 corporate clients. O'Shea was the principal point of contact for 5 of those, who were all based in WA and SA. Now, they were mining clients who required heavy earth moving equipment. NPE also supplied heavy earth moving equipment to the mining industry in WA and SA. Another important factor was that of the 410 members of Emeco's Australian workforce, only 21 of those employees, who all held senior positions, had post-employment restraint obligations. Well, I told you that some of the restraints were unenforceable, and I earlier told you that non-competition restraints are harder to get up on when you're enforcing them for an employer. But in this particular case, the non-solicitation restraints were found to be unenforceable, and the non-competition restraints were enforced. I just wanted to pose the question why anyone thinks that the non-solicitation restraints might be unenforceable. I'll give you a hint. It relates to scope. Yes, Troy? Yeah, disqualified, actually.
There's only a small number of clients, so everybody knows what the client base is.
Well, that's correct. If you look at the definition of client, the restraints are drafted far too broadly to pick them up, because it applies to clients and prospective clients with whom O'Shea had no personal connection. It applies to clients with whom he's had no business dealings or has any knowledge about, because it applies to all of Emeco's clients. And bear in mind that they operate throughout Australia and also overseas. But nevertheless, the court held the non-compete obligations were valid and enforceable, and a permanent injunction was issued restraining O'Shea for a period of 6 months. The court found that there are a number of legitimate interests capable of protection. He had developed a substantial customer connection with all 5 of the corporate clients he looked after, and also another prospective client they were looking to harvest. He was also privy to confidential information which was capable of supporting the competitor restraint with the court. The court observed that confidential information clauses were included in both of Emeco's and NPE's employment agreements with O'Shea, and indeed confidential information was broadly defined in the Emeco agreement to pick up most pertinent points of client information, or parts of client information. He was also privy to other commercially sensitive information, including, amongst other things, expiry dates in customer contracts, pricing terms and conditions, the identity of key decision makers within the customers, and also their drivers for decision making. In terms of scope, the court held that the restraint was no broader than reasonably necessary to protect those legitimate interests because it was limited to a 6-month restraint duration, which was not too long because the employer's commercial contracts with its customers were typically for a 6-month term, and some of those contracts would shortly expire. The geographic area was limited to WA, and O'Shea was found to be likely to be able to find alternative employment in another industry because this was the first time he'd actually worked in the dry hire industry with Emeco. So, and this is often a factor that's overlooked, as I said earlier. The court made an assessment that O'Shea could get work somewhere else outside of the dry hire industry. I wanted to also run you quickly through this Queensland case of Tokodi. Now, it's an example of a typical bona fide cascading restraint clause. It's the type of restraint, well, it's a non-compete obligation. It has sending obligations in respect of the duration, and it also applies cascades in terms of geographic area of operation. In respect to geographic area of operation, in this case, it wasn't contested that the restraint should apply throughout Australia. That is the maximum option, because Tokodi's lawyers conceded that she basically undertook national sales activity. What was contested in this case in particular was the duration period, and that's because Tokodi decided to sit on the sideline for 3 months but then join a business competitor of her former employer. So she obviously got some advice that 3 months was a reasonable bet for her in terms of the reasonable duration of the restraint. Just to give you some background facts so you can understand this a bit better, the employer was Mondial Assistance, which was an insurance provider that specialised in providing insurance to the customers of travel providers such as Webjet and Virgin Australia via e-commerce arrangements. So you'll often see it on those websites. You can purchase travel insurance which is marketed to the consumer through the travel provider's website. Tokodi was employed in senior sales roles as a senior executive for over 10 years and reported directly to the CEO. Prior to her resignation, she was on a salary package of $235K per year plus super, and she was also entitled to an annual bonus. Her employment agreement contained the restraint of trade clause on the slide. And as I said, she sat on the sideline for 3 months and then joined another travel insurer, Covermore, after her resignation took effect, following the expiration of that 3-month period. Mondial commenced proceedings and sought an injunction prohibiting her working for Covermore for the balance of the 12-month term. The court found that the relationship between Tokodi and a number of the travel providers was critical to Mondial's business. She had direct dealings with important representatives from these key clients. There was evidence of her entertaining these people at sporting and entertainment events. And the court accepted on this basis that it was more probable than not that at least some of these key client relationships were such that there was a real chance that if she left Mondial, it would contribute to a change in their preferred insurance provider. She was also involved in tendering and negotiating contracts with these key clients, and she was aware of their commercial terms, including the commissions paid to Mondial, and she was privy to other commercially sensitive information specific to the insurance industry, such as the extent of claims received from insurance issued through certain clients, which thereby affected premium levels and profitability. These legitimate interests warranted a restraint in the court's opinion. The key question was, what was a reasonable period of time to restrain her from working for a business competitor? In assessing that, the court held it was necessary to identify what was the relevant risk to each type of legitimate interest which the employer was trying to protect. This involved an assessment of the time during which the advantages of the personal connection with the clients and the knowledge of the confidential information would diminish to such a point that they'll be no longer worthy of protection. Now, in respect to the customer connection, Dakota had been with the company for over 10 years, so it had taken her a long time to build up the personal connection she had had with these travel providers. So, in the court's view, it was going to take quite a long period of time for a replacement employee to build up anywhere near that type of personal customer connection. And in respect to confidential information, the court found it had probably a shelf life of more than 12 months because Mondial's standard contracting arrangements with the travel providers were for a term of 3 years. So on that basis, a restraint for a period of 1 year was found to be reasonable. I'll quickly wrap up. When should you negotiate restraints? Well, look, it's common that you should, well, the best time to get them in place is prior to the commencement of the employment relationship and indeed the commencement of work. Because if you have a situation where the contract is signed after work is commenced, there is an argument that there hasn't been valid legal consideration provided for the restraint. And that goes back to contractual common law principles that past consideration is not good consideration. I won't bore you with the details of that, but basically past consideration is not good consideration in the eyes of the law. So when you strike the bargain with the employee, with the restraint obligations, the consideration for those obligations is the commencement of work. So get them in place before the employment relationship actually physically commences. You can also introduce restraints during the employment relationship. There needs again to be valid consideration provided. You might want to look at revising or introducing new restraint obligations when the employee is promoted to a more senior role and has exposure to more important clients, and also when the employer's business activities change and that impacts upon the employee's key duties and responsibilities. Again, as I mentioned, you need to provide valid consideration. A good time to try and negotiate and get them signed up to these new obligations is when you negotiate a salary review and tie in the salary review to signing up to the contract with the new restraint obligations. You can't force an employee onto an employment agreement with restraint obligations, so use the carrot approach rather than the stick. The stick's unlawful. And in terms of termination of employment, it's not unusual to use a restraint in a deed of release in respect to senior executives and key employees when they depart, and you can often negotiate those in return for any ex gratia severance payment which you negotiate with the key employee. Just a couple of key takeaway points. I think you should really realise after today that you should only use restraints for select employees, that is key employees who leave and can actually damage your business. So you need to make an assessment at the start of the employment relationship and before you get the contract in place about what are their key terms and key duties and responsibilities, with whom they're likely to have important dealings and relationships with, and what you can and what you can't legitimately prevent them doing after the employment relationship ends. You need to tailor the restraint. You need to beware using standard boilerplate precedents, which are a one-size-fits-all sorts of situation. The restraint needs to be tailored to the role, the relevant business industry, and the employer's legitimate interests which you're trying to protect. And thirdly, beware when recruiting. You need to be on the lookout in respect to senior employees about whether they're subject to any ongoing restraint obligations to their former employer. You want to avoid a situation where you're sued for inducing that particular person from breaching their restraint obligations to their former employer. So as part of your due diligence in the recruitment process, you need to ask the question whether they're subject to any restraint obligations, and if so, make an assessment as to whether they're valid and enforceable. And subject to those due diligence inquiries, you can then put in appropriate strategies in place in terms of who they can talk to, who they can't, etc., so that you're protected from any type of potential claim for inducement or breach of contract. I see that people are keen to get moving. been a pretty long session, so I'll wrap that up now. Thanks.